Good morning, sir.
How are you?
We're fine, thank you. And how are you?
Very good. Very good. Thank you very much.
Morning, sir.
Morning. How are you?
I'm fine and true, sir.
Very good. Very good. Marvelous. Thank you. All right. So let's begin our lecture. Let me just bring in more people that are joining in. Okay. So today we are supposed to be winding up on the topic that we started looking at last week on Monday. We looked at it on Friday as well. So today, I think the only thing that is left for us to do is to look at the case on the subject of parliamentary privileges and immunities. And after that, we shall proceed on to looking at the concept of bicameral and unicameral legislative institutions. And of course, under that topic, we're not going to spend so much time because you won't be examined on that. It is not part of the course outline. In fact, even us to have to spend a bit of time discussing it is just that I thought it is an important topic that we just touch a bit on it. Otherwise, you will not be examined on it, and therefore ordinarily there would be no need for us to even spend so much time on that. Okay, so we gave you the case of Peter Sio versus Times Newspapers Zambia Limited. It is a case of 1987. Now, I mentioned that that is a very, very important case on the subject of privilege and immunities that parliamentarians basically have. The reason why we are saying that is simply because that case, illustrates to us that it is not actually just parliamentarians that may be entitled to the enjoyment of these privileges and immunities that are basically available to the members of parliament. It also applies or extends. These immunities would equally extend to ordinary citizens like yourself and myself. If we reproduce something, that was spoken on an occasion of privilege while in parliament, and we reproduce it, and it is it is a defamatory matter, and then we are taken to court. What the case of Peter Sio is basically telling us is that the plaintiff, or the complainant would not succeed in suing us because of the aspect of privilege. The statement that we would have reproduced, would have been made on an occasion of privilege. And as such, therefore, we would be as much protected by the privilege as if we were ourselves member of parliament. So the case of Peter Sio is here. This is the case that I said we should basically go and look at. I identified three things that we should basically discuss this case from. One, we said we look at what the brief facts of a case were. Secondly, we look at what the decision in the matter was. And then thirdly, we look at what the rationale, what the justification basically for the decision that was made in the case was, meaning what was the reasoning behind the decision that the court in that case basically arrived at. So it's an assignment that I gave the class for us to go and read through, and of course to come here and to discuss what exactly the matter was about, the decision that was made in the matter, and eventually the reasoning, the racial decidendi behind the decision made made in the case, basically. All right, so I'll open it up, members. I'll open it up for discussion. I'll open it up for discussion, meaning I'll open it up for any person that would like to start speaking about the case in light of those three things, that we have just spoken about: facts, briefly, decision, rationale behind the decision. Okay, members, anyone to take it up? Could we have someone to take it up? What were the issues in the case, briefly? Members, anyone? The case of Peter Siwo versus Times Newspapers Zambia Limited. Briefly, what were the issues in that case? Has anyone a record? Not anyone has it, but we all should have, of course, because we all must have read the case. That was the assignment that we gave to ourselves, that we should basically read the case. So is anyone able to come in, members, and just guide the class in terms of what the issues were, meaning the story, the facts of the case? What are the facts of the case? What are the decision made arising from the facts? What are the decision made arising from the facts? And what was the rationale behind the decision? Members? Hello, members, anyone? Hello, members? Is anyone going to take the lead? Members, are you able to hear me? Is everyone able to hear me, members? Members, are you able to hear me? I hope you are able to hear me, members. Is anyone able to confirm, members, that you can hear me?
Yes, sir, I can hear you.
Okay, so Precious can hear us. So Precious, what we are saying is that we had given the case of Peter Siwo versus Times Newspapers Zambia Limited for us to go and look at, and for us to establish what the brief facts of the case were, the decision that was made in the case, and the rationale behind the decision that was made in the case. So are you able, members? Are you able to share? You know, that's a case that I gave last week, Friday. And I say that we all need to go and look it up. We read it, we establish the issues in the case, the decision behind the issues in the case, and the reasoning behind the decision on the issues in the case. So I'm expecting someone now to come in and guide the class on those three issues. So could we have someone, please, members, counselor, you know, as an officer of a court, you know, a judge is going to ask you to make your submissions on something, and you're not going to just sit down when in fact you took your case yourself. You took yourself to court to go and present on these matters. And yet when the judge asks you to make your submissions, you are quiet. That will be construed contemptuous by the court. So could Councillor please make submissions? Any one of you, Councillor, could you make submissions on the three issues? One, the brief facts in the case of Peter Siwo versus Times Newspapers Unlimited. Secondly, what was the rationale, or the decision rather, and what was the rationale behind the decision? Members, no one wants to volunteer to give no one wants to volunteer to give the answer to the, yes, Precious.
So can I try?
Yes, of course, Precious, do try. Thank you.
Okay. I think the facts of the case okay, so the alleged libel. Okay, I'm just quoting from the case. So the alleged label arose out of the news item headed "Who deal with the Tau culprits?" Who deal with the Tau culprits, and an opinion column published by the respondent, which alleged that the appellant had connived to swindle the government and plundered the people of Zambia for his own ends. So I think those are the facts of the case.
Okay. So those are the very, very, very brief facts of the case. So where did the publication by the respondents come from? Whatever the respondents published, where did it come from? Councillor Chikwekwete?
It came
yes,
from
Gary?
the newspapers, from the newspaper known as the Times of Zambia.
So those were the publishers, yes. But what they published, where did what they published come from? Yes, Gary?
Hello, sir.
Yes, Gary?
May you please come on the question again?
Okay. So remember last week we had given the case of Peter Siwo versus Times Newspapers Zambia Limited for us to go and read and to establish what the facts of the case were, the decision that was made on the facts, and the rationale behind the decision made on the facts. So Precious just read for us the facts in brief, and she said that there was a libel matter that had been brought against the respondents. The question is, where did what the respondents published actually come from? Ray, do you want to come in and try to give the answer to that question? Whatever it is that the respondents published, where did it come from?
Yes, please. In fact, the newspaper got the news item from a report which was compiled after some deliberations in Parliament.
Okay, and who was the person? Yes, Gary, you have your hand up, Gary. But Ray, you can finish up before Gary comes in. Ray, you can finish up. Who made the statement in Parliament, Ray?
Right, it is the Attorney General who made the allegations in Parliament.
Yeah, so that the Attorney General had made a speech, isn't it, in Parliament about a deal gone bad, isn't it?
Yes, sir.
Yeah, okay, very good. So what exactly did the Attorney General, what was he presenting exactly, and how did someone in the name of Peter Sio feel aggrieved by what the Attorney General had basically presented? What aggrieved Peter Sio from what the Attorney General, what exactly did the Attorney General present? What exactly did he present? Anyone, either Ray or Gary or anyone else, what exactly did the Attorney General present, members?
The Attorney General, when presenting his report, made allegations that Peter Sio and others were corrupt, and they swindled the government of $4 million, which was paid as damages to the plaintiff, whose tender for supply of trucks had been cancelled, and a letter had been secretly written accepting that though the tender had been cancelled, but the plaintiff could still supply the ordered vehicles, and the government of Republic of Zambia would accept them. Then at some point, he was invited by the chairperson of TAU to America, which raised suspicions and further allegations that he was involved in corrupt dealings with the plaintiff.
Okay, all right. Those were facts in brief in the case of Peter Sio. So what the Attorney General had done, by the way, was to issue a statement. You know, in Parliament, the Attorney General, I'm sure we know, it should be the same in Zimbabwe, it should be the same in Botswana, it should be the same in South Africa, in Namibia, that the Attorney General is an ex officio member of Parliament. I hope we do know what the meaning of ex officio is. If you do not know, please let us know so that we can explain. The Attorney General is an ex officio member of Parliament, and in matters where the government, you know, is involved as a party to a contract, you know, in matters where the government is involved as a party to a contract, and that contract does not materialize as envisaged, and the government perhaps is made to suffer a loss or damage arising from that, or even damages arising from that, the Attorney General, like any other minister, in line with the concept of checks and balances, the Attorney General would be required to issue what ordinarily would be referred to as a ministerial statement to explain the circumstances under which something basically happened. So that is what happened. The Attorney General was issuing a statement in Parliament about, you know, this loss of $4 million that the Zambian government lost. That is in 1987. That is so much money at that time. 1987, $4 million was quite a lot of money, just as it is quite a lot of money today. Now, What transpired, like Ray said, is that the Zambian government had gone into a contract with TAW, company of the United States of America, which is in the business of manufacturing aeroplanes. The deal, or the contract, not the deal, the contract was, of course, for the supply of aeroplanes by TAW to the government, to Zambia here. And Mr. Peter Siwo was more like the agent of the Zambian government. Mr. Peter Siwo was the agent of the Zambian government who was going between the company TAW and the Zambian government here. Now, like Ray said, Mr. Peter Siwo, at some occasion, on 2 occasions in fact, he had been invited to the United States of America by TAW, paid for everything. And that invitation basically, on those 2, on the occasion that he visited, when he came back, apparently he had written what are known as waiver letters. A waiver letter is a letter that exempts you, a party to a contract. It exempts you from fulfilling certain obligations to a contract, so that even if you have not performed certain parts of a contract, that may in fact make the core of a contract, which is a condition to the contract. If you say that this contract has been executed, there are certain fundamental elements that, or conditions, that must just be fulfilled in the contract. If they are not fulfilled, then it will be said that the contract has basically been breached. So there was one provision in the contract between TAW and the Zambian government that seemed quite onerous. It seemed quite onerous on TAW to basically fulfill. So what Peter Siwo did was to write a waiver letter telling TAW, after the invitation, of course, telling TAW that they did not, in fact, need to meet that strenuous or that strenuous condition that was contained in the contract, and that even if they did the other parts, if they did the other parts, not even if, but if they did the other parts to the contract and omitted on that, it would be deemed that the contract had been executed and that they would actually be paid for having done that part of the contract, which they basically could do. And that's exactly what they did. So they performed part of the contract, and the one that Peter Siwo had written to waive, they did not. Now, Peter Siwo did not have the authority of a government of the Republic of Zambia, which he was representing as an agent in that contract. He didn't actually have the authority to do a waiver on the most required and perhaps most onerous or stringent condition of a contract. And Peter Siwo wrote that letter and withheld, without the authority first, without the authority of the government, and also withheld. So Peter Siwo basically withheld. He withheld the letter which was waiving the requirement by TAW to perform that part of the contract. So after they performed the contract, then they demanded payment. And the Attorney General, of course, with the relevant ministry said, no, but we cannot pay for this contract because it is not fully executed in accordance with the terms and conditions of a contract. TAW said, no, but what do you mean? What do you mean? It is not fully executed in accordance with the terms and conditions of a contract. We have this letter here, which indicates that, you said we could actually proceed with a contract without even having to meet this other requirement that you are now saying we need to meet. and the government said, no, we don't remember any such letters at all. There was no waiving of this important condition to the contract. So no, but look, this is a letter. Then the government refused. So later it was discovered that in fact it was Peter Siwo who had written that letter and made TAW believe that it was a letter that came from the government of the Republic of Zambia with the full consent of the government that the contract could in fact be executed even without having to meet that most stringent condition to the contract. So when the government refused to pay, Peter Siwo, to pay TAW, TAW decided to take, according to the contract, of course, the contract stipulated that the matter, rather than being taken to court, the matter will be taken before an international arbitration ADR, meaning alternative dispute resolution mechanism. So that is what transpired. The matter, was taken for arbitration, and in the arbitration proceedings, TAW won the case because there was clearly evidence showing that the agent of the Republic of Zambia, which was Peter Siwo, had indeed written letters of waiver, and there was absolutely no way that TAW could have known, because all along TAW had been dealing with the government of the Republic of Zambia through Peter Siwo. So TAW believed that everything that Peter Siwo did and said had the blessings of the principal, which was the government of the Republic of Zambia. So in law, TAW is what would otherwise be referred to as an innocent buyer of bona fide, a bona fide innocent buyer in commercial transactions, and therefore could not be made to suffer for the misdeeds of an agent of the principal. So the arbitration awarded the damage that, not the damage rather, but the contractual price of $4 million. The arbitration awarded TAW the arbitration or the contractual price of $4 million, which the government of the Republic of Zambia had to pay, and therefore suffered damages, as Ray had just said. Now, arising from that, of course, the matter became public knowledge. The matter became public knowledge, and it had to be made known to the public what exactly had transpired. So the avenue through which it had to be made known was through a speech in Parliament by the principal legal advisor to the government, which is the Attorney General. So the Attorney General issued a statement to Parliament explaining, outlining everything that had happened, and these were the brief facts. Now, I enjoy to read what transpired, especially when His Lordship is narrating, what was exactly happening in Parliament, and the response that the members of Parliament were having as the Attorney General was actually giving the speech, the response that the members of Parliament. I enjoy to read it myself because I like to picture what is happening in Parliament as the Attorney General is reading the responses that the members of Parliament are giving to what the Attorney General is basically reading and all that stuff. So let's look at this. Let us look at this, members. So from here, Peter Siwo, this is Times newspaper, Zambia Limited, is a classic case illustrating the statement above. Which statement above? This is a statement where Maitland said that a member may accuse any person of the basest crimes, may do so knowing that his words are false, and yet that person will be unable to take any action against him. We said it is not an accurate statement. That's what we said last week, Friday. It is not an accurate statement to say, and yet that person will be unable to take any action. No, we said he will take action or she will take action. Only that when that action is taken, the courts will say that this is a matter falling purely under privilege. And the privilege basically is an absolute defense. So here now, arising from what Maitland said, we are saying that Peter Siwo versus Times newspaper, Zambia Limited, is a classic case illustrating the statement by Maitland above and how privileges of parliament and its members have been considered by the courts of law in Zambia. The appellant sued the respondent for libel damages, contending that the words used in an article headed "We will deal with TAW culprits" together with an opinion column published by the respondent alleging that the appellant had connived to swindle the government and plunder the people of Zambia for his own ends, made by the Attorney General to the National Assembly, were defamatory. In response, the respondent contended that the words were a fair and accurate report of proceedings in public in the National Assembly and published on an occasion of privilege, and that the words were true and fair comment. In the High Court, the case was dismissed and an appeal to the Supreme Court made on ground that the defense of absolute privilege could not stand because the respondent, the Attorney General, in his statement to the National Assembly, had not used the phrase connived to swindle or said that the appellant was plundering society for his own ends. The court held that where privileged words could lead to a reasonable inference that a defendant was guilty of certain activities, it is not actionable to take or to make reasonable comments thereon. Now, dismissing the appeal by 3 judges, all of these 3 judges eventually became Chief Justices of the Republic of Zambia. His Lordship, Mr. Justice, Deputy Chief Justice Matthews Ngulube, His Lordship, Mr. Justice Ernest Sakala, and His Lordship, Mr. Justice Gardner. And Gardner delivering judgment. Stated as follows. Now, I want you to listen. He starts with, first of all, narrating briefly what the facts of the case were. Now, like I said, I like to read this myself because I want to put perspective. I want us to feel like we are actually in Parliament as the Attorney General is reading, this statement to the parliamentarians, and how the parliamentarians are basically having to respond to this statement as it is being presented in there by the Attorney General. So this is what His Lordship, Mr. Justice Gardner, starts to say on this matter. The question before this court is not whether the appellant swindled the government and plundered the people, but whether the words of the Attorney General in the National Assembly could lead to a reasonable inference that the appellant was guilty of such activities. It is common ground that the Attorney General did not use the expression conniving to swindle or plunder. It is also common ground that the Attorney General said that the appellant had written waiver letters without authority and concealed the copies of such letters, as a result of which the Zambian government suffered a loss of $4 million, which had to be paid to TAW. There is no doubt that the Attorney General meant that the appellant had deceived the government. The Attorney General also said that one of the things that the appellant had done was to visit the United States at the invitation of the president of TAW. It is clear from the context that the Attorney General's reference to that visit was an indication that, in his view, the visit had a sinister meaning. Throughout the Attorney General's address to the National Assembly, setting out the actions of the appellant, he was interrupted by cries of shame. Cries of shame. A nation of scandals, and that is very serious. It is obvious that the Attorney General was saying that the appellant had done something wrong. And it is equally obvious that the members of the National Assembly thought that the appellant's actions as related by the Attorney General were shameful and scandalous. It certainly cannot be argued that the Attorney General was saying that any of the actions of the appellant were innocent. And we accept that the meaning of the Attorney General's words was that the appellant had been involved in deceitful activities, in the course of which he had been to the United States at the invitation of the man who subsequently won the arbitration case against the government and received $4 million. This case, or this was a clear suggestion, that the appellant, because of his questionable association with the president of TAW and his deceitful conduct on behalf of that organization, was himself a beneficiary from such conduct. It follows, therefore, that the respondent's use of the word swindle in the newspaper article was a fair and accurate report of the privileged proceedings in the National Assembly. The use of the word plunder in the opinion column, although very strong, was nevertheless fair comment rising out of the meaning of the Attorney General's privileged words. And there is a complete defense to the action, as the Attorney General's words before the National Assembly led to the comments of the Minister of Home Affairs. The respondent's report of such comments was equally covered by the same defense. For the reasons we have given, the appeal is dismissed with costs to the respondent. Okay, now, this is, like we have been saying, such an interesting case. So you have 3 people in this matter, but you have 4 components involved in this matter. But of course, the matter is only between the newspaper and Peter Sewell. The 4 components are: 1, the Attorney General, who issued a statement in Parliament outlining the questionable conduct of Peter Sio as he dealt as an agent of the Republic of Zambia with TAW of the United States of America. So, arising from what the Attorney General had said, the Minister of Home Affairs, wrote an article in the Times newspapers, and it is in that article where terms like plunder, swindled, connived to swindle and plunder the people of Zambia. It is in that article, which was written by the Minister of Home Affairs. Now, that article was then published by Times newspapers. It was made published. Remember, in the law of torts of defamation, publication is one very important, very essential ingredient in securing a case for defamation by a plaintiff. If you can't prove that there was publication, of course, it means that you cannot successfully sue in defamation. So this is what happened, members. The respondent Times newspapers published that article, which was written by the Minister of Home Affairs, arising from what the Attorney General had presented in Parliament. Now, from there, of course, Peter Sio was aggrieved, not by the Attorney General, not by the Minister of Home Affairs. He was aggrieved by Times newspapers for having published that article written by the Minister of Home Affairs arising from the speech of the Attorney General in Parliament. So he sued for defamation. In the High Court, the matter failed. In the Court of First Instance, which is the High Court, we need to be, if we are not very familiar with these terminologies, we need to be very, very familiar with them. So a court where a matter appears first, is said to be the Court of First Instance. So in the Court of First Instance, in this case, which was the High Court, because of the amounts involved, the High Court dismissed the case. So Peter Sio appealed to the court, to the Supreme Court, and it is in the Supreme Court now where there are the three lordships, as we have just read there, made that statement. So this case, members, like I mentioned last week, applies or gives us information that it is not in fact only the parliamentarians that may be enjoying this privilege of parliament, but also ordinary citizens like you and me, who, when we reproduce something that is spoken in the National Assembly and on an occasion of privilege, we are as much protected by these privileges and immunities as if it were us ourselves, the members of Parliament, who were in fact making such a statement in Parliament. So this is an important case that we should always know. And of course, there are other cases that you are going to come across on the issue of parliamentary privileges and immunities. But this particular case, very, very, very important. So from what we have read, three things have arisen. One, what has arisen is that it has given us what briefly the facts were. Secondly, it has told us the decision that was made. And thirdly, it has also told us the rationale or the reasoning the reasoning behind the decision that was basically made. And like I always say, and I've always been saying this for the last 18 years of my lecturing career, that in law, it is these three things. Even as you go to court, you just need to be familiar with these three things. One, what were the brief facts of the authority, the precedents that you intend to rely on? Secondly, what was the decision made in there based on the facts as you would have known them? And thirdly, what was it that influenced the bench, the court, or the judges to arrive at the decision they basically arrived at? So that is a case of Peter Siwo versus Times Newspapers Zambia Limited. All right, members, we have finished, therefore, looking at the subject of parliamentary privileges and immunities. We have finished the subject, but there is a lot more that you should read on the subject, especially those of us who have copies of Constitution, governance rather, and democracy. You will need to look at that. You need to look at that. I would like us to just spend a bit of time looking at freedom from arrest. Looking at freedom from arrest. What we have been talking about has been freedom of speech and immunities. Now, when we talk about immunities, we are basically talking about being exempt. Now, when you talk about immunities, we are basically talking about being exempt from any legal proceedings. But legal proceedings is not the same thing as arrest. You know, you are arrested, and of course, once you are arrested, you will need to be taken to court. But then there are certain instances when you may not actually be required to be arrested, because when you are arrested and you are taken to court, it is a foregone matter what the outcome in the courts of law would be. So court is even equally exempt. Arrest is equally exempted in certain circumstances or in certain instances. So freedom from arrest. Let's just quickly read on that, and then we end on this subject so that we can now very quickly introduce another topic, which is bicameralism and unicameralism. Okay, so freedom from arrest. Also, as already observed, freedom or free speech is essential in any democratic society. Hence the need to have such protected under the Constitution and expressly provided by acts of Parliament. Privileges in terms of speech, important to recognize that, members, speech. We mentioned last time that these privileges only extend to freedom of speech. If it is not speech, remember, you can't at all be protected by the privileges and immunities that are guaranteed in Article 76 and in sections 34, section 3, and section 4 of the National Assembly Powers and Privileges Act, Cap 12 of the laws of Zambia. So privileges in terms of speech in the House, however, may not suffice if no further protections are guaranteed to members from arrest, much as the courts may refuse to hold a member liable for statements, however repugnant, made in the proceedings of Parliament. The need to protect members from arrest for conducting themselves in a certain manner in their capacity as members has equally been protected. Section 5 of the Act expresses this protection accorded to members from arrest for the duration of meetings in the House, for the duration of meetings in the House, for the duration of meetings in the House. Freedom from arrest has not been guaranteed as much as freedom of speech, whereas protection for statements made in Parliament during proceedings extends even to statements in debate that may border on contravening Section 69 of the Penal Code, that is the one that provides for defamation of the president. The members are fully protected both by the Constitution, acknowledging the privileges, and through the express provisions of the Act above. For arrests, however, there are exceptional circumstances where members may not succeed in claiming privilege or privileges in instances involving debts of a criminal nature. From the construction of Section 5, it is clear that members do not enjoy complete freedom from arrest. Members are therefore very much subject to the law where they commit criminal offenses, and they cannot plead privileges in defense. No privilege allows a member to act in a criminal manner and seek the shield of the Act. So this is what Section 5 of Cap 12 of the laws of Zambia basically states. Says, for the duration of a meeting, now for the duration of what? Of a meeting, members shall enjoy freedom from arrest from any civil debt except a debt the contraction of which constitutes a criminal offense. For the duration of a meeting, members enjoy freedom from arrest for any civil debt except a debt the contraction of which constitutes a criminal offense. So now, any other offense other than speech, of course, other than arising from speech, for example, under Section 69 of the Penal Code, which is criminal defamation, members are protected, so they can't be arrested as long as they are in the House arising from speech, because now that is guaranteed by freedom of speech. The guarantees from freedom of arrest are to do with those matters that do not border on freedom of speech. So if you commit a crime while in Parliament, for example, you start a fight in Parliament. Yes, while you are in Parliament there, you may not be arrested, but the moment you leave Parliament for having perhaps assaulted someone, occasioning grievous bodily harm, assault occasioning bodily harm, not even grievous, assault occasioning bodily harm, which becomes a battery. You cannot say, I did that in Parliament, and it was on an occasion of privilege. You cannot do that. You cannot at all do that. Privileges are not going to stand for you in such instances as that. Okay, so we have finished looking at excuse me, we have finished looking at the aspect of parliamentary privileges and immunities. Let me just invite questions. Let me invite some questions before we proceed on to looking at bicameral and unicameral legislatures. Members, do we have any questions at all before we look at unicameral and bicameral legislative institutions? Members, any questions at all? Kindly put your hand up if you have a question. If there's a clarification equally that you'd like us to make, kindly put your hand up so that we can then address the concerns, the questions, and all that which you may have. Any members? Members, kindly ask. It's very, very important that you ask questions. Yes, Bruce.
Yes, sir. My question is, Members are still exempted to when it comes to making statements that are defamatory to the president.
Yes, especially now, because now, now, Bruce, what it means is that because that law now has been scrapped off, just like the death penalty, you know, that law now has been scrapped off, that describes an statement under section 69 as defamation of a president. It is no longer sincerest apologies, members, for that loss of connectivity. I think the power outages that we are having currently is affecting a lot of things. But I was responding to a question from Bruce, where we said it does very much. It does very much apply now, especially now. It is even more applicable, because now, with the scrapping off of section 69 in the penal code, which basically criminalizes defamation of a president, is made criminal. It doesn't apply anymore. So one can speak even outside parliament. You know, you can say what you would say. You would not fall within the context of section 69. But of course, it is not to say you cannot, it is not to say that you cannot be sued. You will very much be sued. Okay, Bruce, is that okay?
Yes, sir, it is okay, but I was wondering why Raphael Nakachinda was sentenced to 18 months imprisonment with hard labor when that law was actually removed by the president. I don't know.
Yeah, okay, that's a very good question. So you know, the law, unfortunately, the law does not act in retrospect. Bruce and other members, the law does not act in retrospect. So the defamatory statements for which Mr. Nakachinda was arrested were made before the law was removed from or was struck off the statute books. So that was a matter ongoing. He had to face the law because at the time he uttered those or he made those utterances, the law was still in force and he was already arrested and charged. So that basically had to be left to run its course and to then be sentenced, because at the time he did what he did, the law was still very much in force. Is that okay, Bruce?
Yes, sir, it is okay. So I think, is it the same case when it comes to sedition, section 59 of the Penal Code, and also treason?
No, the law has not been amended on that. Those laws are still effective and very much applicable. Only Act Section 69 basically has been touched on.
All right, sir. Thank you.
Okay. All right. Any other questions, members? Do we have any more questions from other members? Do we have any more questions, members, before we leave this subject? Once we leave this subject, of course, unless during revision time, but we are not going to revisit it. So it's imperative that if we have questions, we ask those questions now. Do we have any questions at all on this, on the subject of discussion today, members? No questions. Okay. If there are no questions, I'm not seeing any hands here. Neither am I seeing any mics on. So it means that we do not have any questions at all. Okay. So let us then proceed on to looking at bicameral and unicameralism. Let's proceed on to looking at bicameralism and unicameralism, meaning unicameral or unicameral meaning two chambers of a country's legislature, and bicameral meaning one chamber, or unicameral meaning one, and bicameral meaning two chambers of a country's legislative institution. So let us just look at that. Let me just bring the book on the screen. Just bring the book back on the screen here so that we can then just work with that. So we are looking at now bicameralism and unicameralism. Let's just go to the table of contents there. So this topic, the reason why I thought we look at it, like I've been saying, is simply because you know, we are talking democracy. We are talking democracy, and when we speak democracy, you will find that sometimes the very institutions of democracy are the ones that cause destruction to the democracy that we actually talk about. The very institutions that we say are institutions of democracy, you will find that sometimes they themselves that actually cause the destruction to the democracy that we talk about. And therefore, to make sure somehow that there is some semblance or protection of democracy, you know, that democracy is in fact protected, we put in place certain mechanisms, fundamentals. We put in place certain fundamentals or mechanisms that are going to help in ensuring that democracy is actually made to flourish. So parliamentary structure, The role, let me just read this. The role of parliament in a democracy has been discussed earlier. I think we did discuss this even during our, during our lectures. We did discuss this previous lectures, especially on the subject of separation of powers, and also when we were just beginning the semester, the first 3 weeks into a month of our lectures, we spoke about the three organs of government, where we learned that the institution of parliament mainly is about legislative, but besides just legislative, it's also about upholding the values of democracy, speech, free speech, parler meaning to speak, a place of speech. So we are saying that the role of parliament in a democracy has been discussed earlier. An aspect worth considering when looking at the institution of parliament in a democracy is its configuration. Different countries have different configurations in their legislative institutions. Some have unicameral, while others have bicameral legislative institutions. The liberties to debate in the House or in the houses are a vital aspect in the process of democracy and would bring about effectiveness in the legislative institutions. This chapter examines the structures of legislative organs and how they work to enhance democracy in democratic countries. So, bicameralism, unicameralism. So, bi means two, uni means one. So when we speak about bicameralism, we are basically talking about countries that have two chambers of the legislative organ. We're talking about countries that have two chambers of the legislative I don't know at what point you stopped hearing me. I was not on the screen. I was on the book. I was looking at the book. The screen was not this screen where you are was not on my laptop. So I don't know at what point you stopped hearing me. At what point did you stop? Did I disappear? I had another break in transmission, internet, that is. At what point did you stop hearing me, members? At what point did I disappear? What point was I making? Hello, members, anyone to guide me? When I disappeared, what point was I making?
Okay, so you were actually talking about the bicameral and the unicameral. You said bicameral, it's 2 chambers. Unicameral, it's 1 chamber. So you said you are now looking at the book. You are now sharing the book on the screen.
Okay.
So
yeah.
we
So
are
I
actually
was
waiting
saying.
for the book.
Thank you very much. Thank you very much, Precious, for that. So what I was saying, members, is that for people for countries, not people rather, for countries that opt to use or to have a bicameral legislature, they opt for that because they say it is cheaper. But I was saying that when you have decided that you are going to be a democratic state, when you decide that what you want is basically democracy, you cannot say that having this system is expensive, because democracy is not cheap. And I was saying that anything that is good comes at a price. So you have elections, because that is what democracy is demand. Democracy is demand that you basically have elections. Now, elections are not cheap at all. Elections are not at all cheap. So you're going to have presidential elections, you're going to have parliamentary elections, you're going to have local government elections. Now, addition to those, true democracy may further require that you have a second chamber, which equally shall have to be electable, meaning an additional cost to what you would already be spending. But like we are saying, democracy is not cheap. So most countries that have opted to have a unicameral legislature, you will find that there is no special reason why they have opted for a unicameral legislature, apart from the fact that it is cheaper. That is what they basically say. It is cheaper to use or to have a unicameral legislative institution as opposed to having a bicameral legislature. That is what they say. But like I'm saying, it is not about how the costs of each basically are. It is not about how the costs of each are, which is either a disadvantage or an advantage. So countries that have opted to have a unicameral because it's cheaper, and yet they consider themselves to be democratic or to be democracy, they may simply be shooting themselves in the foot, because as we shall see, unicameral legislative institutions may not really bring about the kind of democracy that as countries you must basically have. Unicameral legislative institutions may not really bring about the kind of democracies that as countries you should have. So to say that it is cheaper and therefore it is better is an anomaly. To say it is cheaper and therefore it is better to have a unicameral legislature, it is basically an anomaly. You need to have a system that is basically going to, you need to have a system that will properly you need to have a system that will basically properly promote democracy. And that system can only be a bicameral legislative so then we need to look at some of the reasons why countries that have opted to have a bicameral legislative institution have actually gone that way. We need to look at some of the reasons why countries that have opted to have a bicameral legislature have actually gone that way. So let's look at countries like the United States of America. For the UK, really, there is no reason why we should read the rationale for bicameralism in the United Kingdom, and you shall see that for the United Kingdom, there is absolutely no special reason why that country opted to have a bicameral legislative institution. Absolutely no reason why kingdom, okay, bicameral legislative. Then, bicameral legislature, for the United Kingdom, it seems before, it evolved as so many other institutions of government in the kingdom have before. The institution of parliament itself evolved to become as we know it today. There was no when you start the history of Westminster, it is not that it starts and to say let us have a parliament. No, something that came about the result of meeting that the king will have a select individuals being of England at the time. So just a minute, members. So the institution of parliament in Britain evolved like any other institution in that country. My laptop will go off. Actually, my laptop is very low, and also I'll continue using my phone. Continue using my members. My laptop, the power on my laptop has just gone down, so I'll switch off the laptop soon. But continue using the phone just in case. Okay. Okay, members. So let's carry on. Let us okay to have a bicameral legislative institution. It is something that evolved. It is basically something that simply evolved with time. On the other hand, with the countries like the United States of America, it was a design it was something that was by design for that country to have a bicameral rather legislative institution. Unfortunately, you will not be able to see what I'm seeing now. On my laptop. What has happened basically is that power has gone, and my laptop is very, very bad in terms of battery. So I'm using my phone, but anytime the laptop may go off. So I'm using the laptop just to see the content on the rationale for bicameralism, but I'm using my phone now for the speaker. Okay, so the United Kingdom, no special reason. However, for countries like the United States of America, they had all the reasons for choosing to have a bicameral, legislative institution. I'm using my modem, so I'm going to start sharing again for the time being when my laptop still has some power. I'm going to be sharing that. Okay. So let me just bring up the document here so that we can move together. Okay. All right. So we are looking at countries like the United States. We're looking at countries like the United States. Yeah. So we say, for example, the United States of America was the only country upon independence to fully put to practice the doctrine of separation of powers, something that came out clearly in the early 17th century in the United Kingdom after the passage of the Act of Settlement 1701. Something that took centuries to implement in the mother country, but whose benefits the United States recognized upon independence and immediately adopted and enshrined in their constitution. The setup of a legislature into a bicameral system was one of the aspects adopted by the United States of America from the United States, and by design created two chambers. A number of reasons have been extended for having a legislative system. They stem from democracy, abuse of authority, staying in line with tradition, example, etc. Four factors, however, were considered in America as having influenced the framers of that country's constitution to establish a bicameral legislative institution. One, familiarity, safeguard measures or safety measures were and compromise were the main reasons for adopting such a system of legislation. So those are the main things. One, familiarity. Two, safeguarding against despotism. Three, safetyism. Four, compromise. Of these, I want us just quickly to run through two of them: safeguarding against despotism and the need to compromise. These are major or the main reasons why our friends in the United States in the United States opted to have a bicameral legislative institution. One was to safeguard against despotism, and then the other was to on the need to compromise. But what does it mean? When we speak about the need to compromise, what exactly are we basically talking about? Familiarity. Familiarity is simple and straightforward. It simply means that before America became independent, when it was being colonized by the major European powers at the time, the French, the Spaniards, the English, all these countries had bicameral legislative institutions, and therefore they extended the same structures of their cultures in the different states that we colonized the United States of America. For independence, the Americans did not see the need. They had how bicameralism, and they had come to enjoy our, and therefore they opted to remain a bicameral legislative structure or system. So familiarity simply means that it is something that they were already familiar with. They were already familiar with this aspect of living. Now, the one that especially is of importance is safeguarding against despotism. Remember, this is what we refer to as the elected dictatorships. So to have a bicameral legislature, what you are doing, among other things, when you have bicameral legislature, among other things, what you are basically doing is to safeguard against despotic tendencies. What do we mean despotic tendencies? I'll give Zambia the Zambian legislature, not Zambia. I'll give the Zambian legislature as an example. And you may relate. Other countries may also perhaps relate to that. When you have one chamber, meaning a unicameral legislature, chances are that that parliament will be overwhelmed, especially where the system that you use to elect that parliament, the simple majority first past the post-election system. Chances are that that parliament is going to be dominated by one political party, which usually will be the political party in government. Now, when that political party has numbers in absolute terms, when they have numbers in absolute terms, where the opposition is like non-existent, where the opposition is almost non-existent, what it really means is they will be able to pass whatever motion that they may in fact introduce in that chamber. Why? Because they have dominated, and you will find, as a case is in Zambia, you will find that parliament, only has maybe 2 or 3 currently in the Zambian state. There is 2 political parties that are represented there. There's a party in government, and there is also the party that was in government before. There is a party in government, and there is a party that was in government before the elections of 2021. Now, the party in government has such a huge majority, and sometimes the party in government trying by all means also to cause by elections in the constituencies that are held by the party now, which is in the opposition, so that they can hopefully win those by-elections to even further increase their numbers in parliament, so that they can now pass whatever it is decision that they would like to pass without so much opposition from within parliament. Now, that breeds despotism. So despotism simply means that you have such huge numbers by the party in government. You have such huge numbers by the party in government that that political party is basically, able to do anything. It is able to do anything that it desires in parliament because of what others refer to as the arrogance of numbers. So, when you have a single chamber or a unicameral legislature, as the case is in Zambia, like I mentioned, chances are that you are going to have a situation where laws, laws and political decisions are being made, not because it is what the majority of the people in the country want to see, but it is because that is what the political party in government, which has such a huge majority to the point where they become dictatorial, that is what the party in government basically wants to see being made. And when you have just one chamber, it simply means that whatever policy issues or legislative matters that are presented in that one chamber, once that passes, there is no other chamber to which such decisions would be subjected. It becomes law. Then and there it becomes law. Now, we have had instances in Zambia here where that can be illustrated. We have instances in Zambia here where that can be illustrated. One instance, what transpired in 1996. What transpired in Zambia here in 1996 when we had the 1996 Constitution passed. The 1996 Constitution was adopted and enacted by the Parliament of Zambia, a parliament that had been over 80% predominantly the party in government at the time. They were able to pass all sorts of laws. They were able to pass all sorts of laws, including the Constitution, which was huge in their favor. Why? Because they had such huge number in parliament, and whatever measure that had to go through parliament was not subjected to any other further scrutiny other than the chamber, where there is one single party with such an overwhelming majority. So, to safeguard against such, that is what we call democratic recklessness. What I've just described here, members, is what we refer as democratic recklessness. Democratic recklessness in that you act recklessly because you have the number. You act recklessly as a democracy or as a party in government because you have the numbers and you are saying we are a democracy. So the other chamber will then work as a mechanism to safeguard against this despotism. The other chamber will then work as a mechanism to safeguard against this despotism. Now, how this chamber is constituted is what Thomas shall determine. Not if you are going to have it constituted in the same manner using the first past the post simple majority outcome of an electoral system. No, it will not make any difference, and it will be worthless, really, to have a second chamber constituted on the basis of the first past the post. So you have the first chamber on the basis of first past the post. You have the second chamber also on the basis of first past the post. It's worthless. It's not going to be of any use whatsoever. So if you're going to have a second chamber, the second chamber must be constituted on the basis of proportionality. The second chamber now must be constituted on the basis of proportionality. Remember what you are trying to do. What you are trying to do is to bring about some level of decency in terms of the manner in which decisions are being made in Parliament. You are trying to move away from that despotic manner. We are trying to move away from that despotic manner of law making and decision making in Parliament to a system that is better going to at least allow decency in terms of how decisions are made in Parliament, decency in terms of how political decisions are made in Parliament. So the only way that that can be done is where now you have some systems of check. You have some systems of check within the institutions of Parliament. You have a second chamber, as the case is in America, as the case is in Britain. In Britain, for example, the House of Commons is an institution of democracy where democratic recklessness is allowed to happen. But it is not everything that passes the House of Commons that shall eventually become law. For whatever legislative measures that the House of Commons would have passed, they have to first go through the House of Lords. They will have to go through the House of Lords. For the House of Lords to approve and to recommend certain adjustments to be made from whatever will be coming from the House of Commons. Same thing in the United States of America. You have the Senate, which is the upper chamber, and then you also have the House of Representatives, which is the lower chamber. So the lower chamber, which is the House of Representatives, it is an institution that is premised on democratic recklessness. Because of the number that a party would have, you would find that the party with a majority in the House of Representatives will basically be the one calling shots on almost everything that happens in the House of Representatives. But it is not what the House of Representatives finally agree upon that shall become law. What shall eventually become law is that which shall now, from the House of Representatives, will go to the Senate. And in the Senate, a decision now to approve whatever will have come from the House of Representatives will be taken. An approval will have to be made, approving measures taken in the House of Representatives. The Senate will have to approve that. And only with a approval or consent of the Senate can whatever legislative proposals or legislative measures that would basically be coming from the House of Representatives actually be passed. Only then would they be passed by the Congress of the United States of America, meaning both the House of Representatives and the Senate would have basically to consent to a measure that is coming from the lower chamber House of Representatives. Like that, you have an inbuilt system of checks of whatever is coming from the legislative institution within a country. That won't happen where you have a unicameral legislative institution. It will not happen where what you have is a unicameral legislative institution. Okay. Let's look at the other of the the rationale. I said we shall not look at so much the other two, but so much of this one and the need to compromise. Now, these members, if what in America to talk about today. Why? Because before 1776, when America declared the War of Independence against Britain, there was no United States. There was only individual states, each of which were being governed by different countries: France, Spain, England. Am I on mute? I'm using my phone. Am I on mute, member? You can't hear me?
I can hear you say.
Hello, member.
We can now hear you.
Please, that you are able to hear me, member.
We can now hear you.
Hello, member. Could somebody confirm that you are able to hear me? Are you able to hear me?
We can now hear you say.
What I was saying basically is that. Okay. All right. Thank you very much. Yeah. Thank you very, very much. Thank you very much. So, what I was saying is that. Okay. Thank you very much. Thank you very much. Thank you. Okay. So, what I was saying, members, is that before 1776 in the United States of America, there was no United States at all. There were individual states that were being governed by the different colonial powers, the Spaniards, the English, and the French. But because of the revolutions in Spain and in France that transpired during the 1700s, they could not maintain or sustain their colonies in America. So their governments, their colonial governments in America collapsed, so that the only country that remained was Britain. And with Britain remaining alone, these states that were under the French and the Spaniards, like overnight, they became more like independent, not necessarily independent, but more like independent. That the only now colonial power that the whole America had to grapple with was England. So what the states now did, the different states of America did, was to decide to come together, and say, look, if we are going to attain our independence, this is the time when there is only this one country that is basically controlling us. So why don't we unite together so that we can prosecute a war of independence against Britain as a united front? That is how come the 13 states at the time, there were only 13 states at the time that formed the Union of United States of America. So they declared war of independence against Britain, and they defeated Britain. Now, after defeating Britain, the question now was, how do we proceed? We have now become independent. But now, how do we proceed from here? Do we go back to our own separate independent entities as we were before? Or perhaps it is in the best interest of everyone if we maintain the union. So they decided to maintain the union. But maintaining the union equally had its own challenges, because within the union, there were some states that wanted to be considered more important than other states because they were bigger in terms of size, meaning they had more resources, and they were also bigger in terms of population, meaning they contributed more in terms of revenue to the union. So they also wanted to be considered to be treated in a special way within the union. That members threatened the unity of the United States of America. So they had to find a way. How do we appease the bigger states, but at the same time also appease the smaller states? The smaller states were saying, well, we are equal partners in this union, because before we were, after all, our own independent states. If we are going to be considered part of the union, we then ought to be treated exactly the same as the bigger states. So now there was a need to compromise. And the best way for them to compromise was by using the institution of the legislature. So they said, we are going to therefore have a bicameral legislature. And in this bicameral legislature, we are going to have an upper chamber, which will be the most important chamber representing equality of the states in the union. And we shall also have a lower chamber. Now, the lower chamber will be an institution of democracy, which shall represent the size of a state. However, the one that is going to have the final say of what happens in terms of legislative and policy matters, the one that will have the final say is the one that shall be considered the upper chamber. So you have then the House of Representatives established in America as the lower chamber, and then you also have the Senate established in the United States of America as the upper chamber. Now, between these two, the Senate represents equality of the states in the union, meaning it does not matter how big the size of a state is in terms of population or otherwise, each state is going to have 2 senators represented at the Federal Congress in Washington, D.C. So each state will only have 2 senators, be it the state of Hawaii, which is a small state population-wise, be it the state of New York, which is a very big state in terms of population. So the state of New York has 2 senators represented or representing the state of New York at the Federal Congress in Washington, D.C. The state of Hawaii, equally small as it is, has 2 senators represented at the Federal Congress in Washington, D.C. However, when it comes now to the House of Representatives, it is the bigger the size of a state, proportionately, the size of a state proportionately will determine the number of representatives a state will basically send to the House of Representatives in Washington. So it is on the basis of proportionality now, based on demography, based on demography. So the bigger the state is, the more the representation it will have at the House of Representatives. The bigger the state is, the more representation the state is basically going to have at the House of Representatives in Washington, D.C. So that addressed the issue that especially the bigger states and the smaller states basically had. However, to make sure that power now rested in the institution that represents equality of the states in the union, the Senate is considered the upper chamber between the House of Representatives and the Senate. So the House of Representatives will propose, whatever it proposes cannot become law unless it goes through the Senate. And while in the Senate, it will have to get senatorial approval. Impeachment, for example, impeachment proceedings, where there is need to have a president impeached, the one that is going to bring the articles of impeachment and have them debated is the House of Representatives. They may even convict. The House of Representatives may even have sufficient evidence to convict a president for impeachment. They will vote and say, we have impeached, but that is not final. From the House of Representatives, the articles of impeachment and the resolution of the House of Representatives will then have to go to the Senate for senatorial approval. And only when the Senate has approved the impeachment of a president will that president then stand impeached and will leave office. That's what happened, if you remember, with Donald Trump. Donald Trump is one president who has faced 2 impeachment proceedings, and on both occasions, the House of Representatives impeached him, but on both occasions, equally, the Senate acquitted him. That is how it works. So it is the arrogance of numbers in the House of Representatives would make them do things perhaps that may simply be bordering on political patronage or political inclination. However, when you have this other chamber now will look at the bigger picture, because it would have, if it is an electoral system which is proportional representation, it will have different political parties. If it is, as the case is in America, based on just 2 states, for the senators to really be convinced that they should support a measure coming from the House of Representatives, it should not have any political connotations to it. Otherwise, if it has political connotations, it is not in the best interest, therefore, of the country. It is something that is to interest or to benefit the party that might have a majority of representatives in the House of Representatives of the United States of America. So members, the necessity to compromise, the need to compromise is one very, very important reason why our friends, in the United States of America opted to have, besides safeguarding against despotism, but the need to compromise was one very, very, very important. Now, coming back to countries like ours in Zambia here, we are now in the process of doing what is known as the electoral reforms. And Zambia, Lusaka Goldsmith University is going to be making submissions on the 28th. The submissions are 28th, 29th, up to 30th of October. There's an electoral reforms technical committee that has been set up. We want to reform the country's electoral process, among other things. So we shall be making submissions to the electoral reforms technical committee set up by the Ministry of Justice, and they have been going around the country basically receiving submissions from stakeholders. So Lusaka Goldsmith University is also going to be making submissions there. And our submission basically shall be that for purposes of elections to the office of parliament, we need to have an electoral system that is going to bring about proportionality, so that there is even representation of the different political parties, so that there is not one single political party dominating the National Assembly, which then eventually would end up becoming what here we are referring to as elected dictatorships. Okay, members, so we stop here, read more. All these things that we are talking about are in constitution, governance, and democracy. Those of you who already have got a copy of that book, you are able to follow and you can see everything that we are talking about. So read through there, and after the topics, you read further. So we are going to have our next class on Friday, and the next class I would like us to look at assignments. I would like us to look at assignments, especially presentation of assignments, and then we shall also spend a bit of time maybe looking at some past papers. But for this particular Friday, I would love us to really look at, assignment presentation, because I have seen that some of us still are grappling with the issue of assignment presentation. It's very, very important that as we are learning, as we are teaching, as we are lecturing, it's imperative that the students we are lecturing to are being responsive to the things that we are basically teaching them. Then we get to know that there is learning that is happening. It is a different matter when you spend time talking about this and that and that and that, then somebody submits an assessment, they are then doing the very opposite of what you were teaching them. Then there you see that the process of learning is not actually happening. It's a very, very bad thing. The whole idea is that we learn, and the only way for us as lecturers, we shall see that our students are learning is by assessing you. So we assess you. When we see that you are doing what we said you shouldn't do, or you are doing contrary to what we said you should do, then of course it becomes a concerning matter for us. So we have to go through the process of learning all over before you submit your second assignments. All right, members, I'm not going to allow questions now. Please save the questions for this week, Friday, the next lesson that we are going to have, because there's already colleagues of yours from your seniors. Your seniors are already in here. So we are not going to allow questions so that we can proceed on to the next lecture for administrative law. So the constitutional law students should just log out, kindly log out, so that you can then allow for your seniors to start their lecture at 10:30. Okay. Gamchirai Madichengu. Hello, Gamchirai. Just
Hi,
hi, morning, Gamchirai. Just do me a favor, send on the group, send a message on the group that I'm just having a 10 minutes break. I'm just finishing with the class for the first semester. I'm just going to have a 10 minutes break, so we shall begin our lecture at 10:25.
Okay, see, that's okay.
Thank you very much. So you can just do that for me, please.